Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today I'm going to start a series on legal myths. Now, the first legal myth I'm going to tackle is the myths surrounding the Miranda warning. Now, a lot of people think that if the police don't give you a Miranda warning, anything you say is not going to be used against you. But that's not always true. And that's the reason, in fact, that they invite you down to the police station. Because when you are invited down to the police station, you're not in custody, or at least not yet. And that's the whole purpose of it. Because you see, the minute that you're in custody, the minute that you're not free to leave, that's when they have to give you a Miranda warning. Let me explain why. You know the warning. It goes something like this. You have the right to remain silent. Should you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have the right to speak to an attorney. Should you be unable to afford an attorney, one will be appointed before any questioning. Do you understand these rights? Police are routinely issued a card with what the prosecutor wants them to say and what he wants to hear on their body camera or on an interrogation video. But it usually doesn't stop there. If a suspect decides to talk to the police, they're going to get him to sign a waiver. And that waiver specifically says that he or she has been advised of their rights. It lists the rights that they were advised of. Usually they have to check each one or initial each one. And then at the bottom it says, knowing that I have these rights, I hereby waive these rights and agree to talk to the police. What it doesn't say, and perhaps it should, is because I'm an idiot. There's a reason why Miranda was decided the way that it was, and that's because in spite of TV and movies and civics class, lots of folks did not understand their basic rights under the Constitution or how they applied. Now, Miranda versus Arizona was a landmark U.S. Supreme Court case decided in 1966. The case dealt with the admissibility of statements obtained from a suspect during police interrogation in the absence of specific warnings about the right to remain silent and the right to have an attorney present, now known by their colloquial name, the Miranda rights. Ernesto Miranda had confessed to a murder during police questioning without being informed of his right to remain silent and his right to have an attorney. Miranda's confession was used against him in trial, and it led to his conviction. The Supreme Court, in a 5-4 decision, ruled that the confession was inadmissible because Miranda had not been informed of his constitutional rights. And of course, for those of us who grew up in the 50s and 60s, this was a sentinel event in our history because there was a huge movement at that point in time to impeach Earl Warren, who was the Chief Justice of the United States Supreme Court at the time, because everybody thought that they were giving away the farm to the criminals. And of course, as it's turned out, that's not been the case. But the decision established the requirement for law enforcement to inform individuals of their rights before custodial interrogation, including the right to remain silent and the right to an attorney. The Miranda decision is significant because it was the first time that the court had really enforced an individual's Fifth Amendment rights against self-incrimination during interrogations. Now, one thing that I don't think is popularly known about the Miranda rights, they don't attach until you are in custody and subject to interrogation. Let me see if I can elaborate. Custody is inherently coercive. When you have handcuffs on your hands, you'll do almost anything to get them off. Miranda rights apply when a person is in custody, meaning they are not free to leave, and their freedom of movement is restrained to a degree associated with formal arrest. The only thing to do if somebody says you are not free to go is to assert your Fifth Amendment rights and to ask for an attorney. Now, a lot of times you won't actually have to get an attorney because they'll realize they've got the wrong person or whatever. But at any rate, anytime you are detained and are not free to go, that really indicates that you are in custody and that Miranda has attached. Now, interrogation is, generally speaking, different from just asking someone's name and birth date and that kind of thing. Those are called the booking questions. You can ask someone's name, social security number, driver's license number, birth date, home address, all of those things Those are booking questions, and you don't have a Fifth Amendment right against telling the answer to those questions. If you are being interrogated actively, what were you doing? What did you do? Why did you do it? That kind of thing, then the Miranda rights attach and you have to receive the warning. But again, just because you don't receive a warning doesn't mean you should talk to the police. It means you should always, under every circumstance, say nothing and ask for an attorney. Once a person is in custody and the police intend to conduct an interrogation, they have to inform you of your Miranda rights. And they have to do that before questioning begins. The thing to say is, I'm going to assert my Fifth Amendment rights. I don't wish to be questioned, and I want a lawyer. And that's it. Now, they can continue talking to you, right? They can say, well, geez, if you were innocent, I would think you'd want to tell us where you were and what you were doing, because, that's the only way we're going to be able to clear you. Well, it's not the only way they're going to be able to clear you. They might consider actually doing an investigation, which is what they get paid to do. But the bottom line is, if they think they have the right person, the way an interrogation is conducted, the police tend to assume that you're guilty until you prove yourself innocent, which is very difficult to do. So again, the only thing you should do, the only thing you really can do, is to assert your rights. Now, if the police fail to provide Miranda warnings when required, any statements or confessions obtained during the custodial interrogation may be excluded from use as evidence in court. It's important to note that Miranda rights only apply to custodial interrogations and don't pertain to general questions or spontaneous statements made by individuals who are not in custody. But here is an interesting little sidebar about that, in that there have been cases where the police continue to talk to someone in order to get them to talk back. There was a gentleman in Oregon who had been involved in a self-defense shooting, and he talked with the detective. They essentially took him out of his house on a night when it was about 28 degrees in his sock feet, in his pajamas, and took him to the station. And that's how they questioned him. You talk about a coercive situation. I mean, he was more or less at their mercy. And after they made him wait for about 5 hours while they went through the scene, a detective came back and got into essentially a bullying interrogation. We'll talk about this more in just a minute. But essentially, he told him, look, I want a lawyer. And then the cop kept talking to him and kept talking to him. And finally, the guy blew up and said something inappropriate to the police officer, and they used that in court against him and secured a murder conviction. Well, the Oregon Supreme Court overturned that case, and the reason they did is because they said you violated his right to counsel. He had a right to a lawyer, and you kept talking to him, and you shouldn't have done that. So usually the courts rein in any abuse of this Fifth Amendment right, but a lot of times cases change the law or alter the law just a little bit, so it's always a good idea to rely on an attorney. And in fact, while it may be necessary to talk to the cops at some point, you want to do that only after you've talked with an attorney and know exactly what you're going to say and what you're not going to say. Now, it's important to remember that the theory behind Miranda is that custody is inherently stressful and coercive. People may feel when they hear they are not free to leave that they can say things that might let them go free. Brittany Zamora, who was a school teacher who was arrested for having an inappropriate relationship with a student, essentially confessed at the police station and then asked, well, can I go home now? And of course, a lot of times that is sort of held out as a carrot in order to get people to talk. But of course, they don't get to go home. And she didn't get to go home either. The Reid technique is a widely used method of police interrogation in the U.S., and it was developed by John E. Reid in the 1940s. And it's been a dominant approach in law enforcement for many years. And it starts with the presumption that the person you're talking to is guilty. So it's designed to elicit confessions from individuals suspected of committing a crime. It involves a structured psychological approach to questioning with the goal of getting the suspect to confess to the alleged offense. And the technique relies on the assumption that certain behavioral cues can indicate deception, and it includes various tactics to assess and exploit those clues. But here's the problem with that. Many of the clues and cues that are in the Reid technique don't necessarily mean that somebody's being deceptive. In fact, in studies, they found that police officers are no better than a flip of the coin in determining whether or not someone is lying. They get it right about 50% of the time. Even professional interrogators, like those with the CIA, may very well only get it right 75% of the time. So it's a science that is not perfected. And again, when you start with the presumption that someone is guilty, which is what the presumption that they start with, well, then you work on the basis of confirmation bias and you build the case to support that bias. You don't interrogate to find the real killer. You're interrogating to get statements that you can use to convict someone. Critics of the Reid technique, like Professor Saul Kassim, that's Kissim if you want to look him up, they argue that it can lead to false confessions as the intense and confrontational nature of the interrogation process may coerce individuals into admitting guilt even if they are innocent. In fact, it happened in the Central Park jogger case. They arrested and convicted 5 innocent boys of a terrible crime, and the DNA that was recovered from the victim positively excluded all 5 individuals. So again, it is not a technique that is suspect friendly. In recent years, there's been an increased amount of scrutiny on interrogation methods, and some law enforcement agencies have modified their approaches to be more in line with the contemporary understanding of psychology and ethics. So if the police start out with a position that you're guilty, that's likely where they're going to end up. So that's why the Miranda rights are important, and that's why you have them, and that's exactly why you should use them. If you have any questions, please feel free to leave them in the comments down below, or the best way to get them to me, I think, is probably to email them. Just let me know what you might need to know. Thank you so much for watching. If you have the opportunity today, do something nice for someone. Today, I made homemade chicken noodle soup and took it into my wife's office so that everybody there could have some chicken noodle soup, because they all seem to have some kind of respiratory bug, and it does have some curative qualities, at least it did for me. So again, just do something nice for someone. It'll make you feel great the rest of the day. Again, thank you for watching. Be kind, be thoughtful, and be back here tomorrow. We'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.